going to begin talking about trial basics. The importance of this is only to give you a sense of how these things work, but also for we talk about mock trial, get a sense of what you're going to be doing if you should participate in that. So it gives you those particulars. So we have to start off with the trial basics, but before that you have to understand sort of what you're there for, right, and how it's sort of structured, which you're looking at. So the first thing is understanding the law. There are two kinds of cases that end up in court, civil or criminal. There's also regulatory, but that's a whole other ball of wax. We're not interested in that. Civil and criminal. Now, obviously, both, in whether it's criminal or civil, have to involve not only parties, which we'll get to, but also, if it's criminal or civil, there's got to be some rule somewhere written that the case is based on. In other words, it's got to be an ordinance and statutes that we're looking at that have been enacted by legislative bodies. Oftentimes, people lose sight of the fact that really what lawyers do is they operate off of statutes and ordinances that have been designed by legislative bodies to address an issue, a problem. Problem crops up. There's some sort of issue that needs to be addressed, and it's resolved. And the word "resolved" there is a bit too strong, but it's addressed by the legislative body, which will write legislation creating policy that's designed to help resolve or manage that particular conflict. So conflicts arise between people and between organizations and the like, and they end up in court. And in court, the rules based on the statutes and ordinances that have been written are going to be adjudicated in some way. So first of all, are we in a civil matter or is it a criminal matter? And we'll get to both of those and kind of lay those out a little bit more. But the important thing here is that there's some government body, local, state, federal, legislative bodies that have written a statute and ordinance that creates policy that's designed to resolve or deal with a conflict of some sort. Even in a criminal case, is a conflict, right? There's some sort of criminal statute that's been violated. So that's what we're really looking at. That's what the whole purpose here is. Now, I want you to keep something else in mind. Because of how long it takes and the costs involved, there are relatively few cases that make it all the way to trial. And really, that's as it should be. You don't want every dispute ending up in trial. The courts would be backlogged and so on. So every effort is made, whether it's criminal or civil, to avoid going to trial. Now, in criminal matters, that might be done because of the caseload, right? There's public defenders. Not everyone can afford a lawyer to defend them in a criminal matter. Public defenders are typically overworked, of course, underpaid, and their caseload may be tremendous. So their job is to somehow manage all this and give someone that they represent some measure of opportunity to, involve a due process, get involved in due process. Oftentimes, in terms of those cases going to trial, they sort of end or plead out before it gets to trial. So somebody will cut a deal. That's how we think about it, right? With the court, that if they sort of admit to having committed that crime, they'll get some sort of break from the court or what have you. And it moves things along. Now, in terms of, those folks that can't afford lawyers, right? They're depending upon that public defender to do the best they can for them. I'm not saying public defenders don't, but there are practical matters there. On the one hand, a private lawyer, and I'm not saying that this is their intent, but they get paid, right? In criminal matters, they've got billable hours. So the more hours they put into it, the more they get compensated. Again, I'm not saying they do that to get compensated more. I'm saying that it's worthwhile under that structure, if you have the money to pay a lawyer or a team of lawyers to represent you, and of course you pay for that. But as I said before, not everyone can afford that. As a consequence, you're sort of in the hands of the public defender, who has just the opposite issue. lots of cases, is not going to get reimbursed, or have billable hours for taking longer with a case. So that's sort of the bare bones of it. The idea here is that get these cases resolved, keep them out of court. Long drawn out battles in court not only get expensive, not only wear on, and cause a great deal of stress. So they wear on the individuals, whether it's civil or criminal. But also, the period of time that it takes, as I've said, is debilitating in so many ways. Not only billable hours, not only stress, but you don't get resolution for a long period of time. So it means you're constantly trying to mount a stronger and stronger case. Although that should be done before, what I'm saying is you're constantly trying to deal with those issues that are going to arise at trial. And you're much better off getting it out of the way. So keep in mind, we're talking about a small number of cases here relative to the total number of cases that we see. There's one other addition to that, which goes outside the system here, which is sometimes you don't, something has been done, someone steals your patent. Some big company takes your patent and runs with it. Now, you have a right to sue because you've got the patent. They've got a lot of money. They're going to use that to get you into court and bury you, in a sense. So you really, even though you have a right, doesn't necessarily mean that if you don't have the resources, that you're going to get your day in court because you may not have the resources to get there. Okay, enough said about that. So obviously, at trial, there's parties on each side of the case, and they're going to argue the law and they're going to argue the facts. And the idea here is that if we look at these facts and we look at this law, a statute, ordinance, and we look at the elements of that, right? So there are particular things, right, that make up that statute, right? So negligence or burglary, there are specific things, if present, those elements constitute, say, burglary, right? Breaking is one, and entering. The statute's written as a full sentence, usually, or a complete sentence, but there are parts to it, right? A breaking and an entering. You've got to show facts if that support that an element has been satisfied. So there was, in fact, an entering because here's how we define entering, and this is what was done. Now, you're going to have to support your definition of what entering is based on case law and that sort of thing, but we'll get to that. Okay, so again, lawyers, stock and trade are words, and legislators, stock and trade are words. Policy is based on words, and so words are the world you live in. That's why writing is so important, right? All right, so the judge decides all issues or questions of law, right? That's the judge's responsibility, right? To determine which laws apply to the case and how they should be applied. Okay, so the judge is aware of the particulars you're coming in with, and they're responsible, as far as the fact, to deal with that. So in jury trials, the members of the jury decide the issues of fact, right, that are contested by the parties, what the real issues are. In bench trials, right, it's going to be the presiding judge performs that function. So what does it mean here? You're listening to the evidence and you're deciding what to believe. That's all it is. Here's the evidence. They support, in my mind, as a juror or the judge, they support, this issue. And that's what we're going to spend time, or that's what we're going to, look to address, all right? So again, we call these people finders of facts, fact finders, triers of fact. They're taking facts. If you were to go to law school, for example, you're going to get fact patterns, hypos, right, hypotheticals. And there you're going to have to look through the facts, determine which facts you're going to really pull that are going to satisfy elements that are required in a statute or ordinance that will then support the issue that you hope the court will base the decision on, right? Those things are tied together. Facts, statutes, ordinances, and issues, okay? All right. Now, there are two broad areas, I've said. There are civil cases, and those civil cases are cases brought. There's no criminal element there, or at least I should say it this way, there's no criminal element that's being examined. Doesn't mean you can't have a civil suit, and there's also some criminal element that is being explored as well. But that's In terms of mock trial and that sort of thing, that's a little bit beyond what we really need to look at here. The idea of mock trial being incorporated in the class here is that we're trying to prepare students that are going to engage in that to understand how things work, right? And so it's important to explore those ideas, so we're going to. So civil lawsuits are things like breach of contract. They're disputes between two entities. I say entities because it doesn't have to be a person, right? Breach of contract oftentimes is not. Personal injuries, defamation, violations of civil rights. Those are the sorts of things, that we're looking at in civil matters. It could be businesses, it could be individuals, it could be government agencies. All right, so you have two parties in a civil case, and we refer to them as the plaintiff. That's the one bringing the case, and the defendant, obviously, is the person that disagrees, or the organization or the government agency that denies or is the one being accused and is trying to exonerate themselves in some measure, or at least think the other side from proving and making their argument. I think what confuses people, just as a quick aside here, is that we have a plaintiff and defendant. The losing party there is possibly going to try and appeal the case. So we say in a case, in the court of origin, we'll say the plaintiff, the case's title would be the plaintiff first versus the defendant, right? So Jones v. Thomas means that Jones is the plaintiff and is saying that Thomas did something, right? And they're there to resolve that issue. Jones the defendant. Now let's just say that in the first instance, the plaintiff loses. Obviously, the defendant is exonerated or what have you. And this is a general sort of overview of how this works in terms of the names, because I think people get confused by that. What you have here is you have the plaintiff bringing it and the defendant, right, making their argument against the charges brought or the claims brought. If the plaintiff loses, right, if it's Thomas, I think I said Thomas and Jones. If it's Thomas that loses, right, Thomas will then go ahead and appeal. And Thomas will then be the appellant. And Jones would be the appellee. But what gets confusing is you could have a situation where the defendant loses and they bring it up on appeal, and then they're the appellant and the other party comes second, and so on. Then if it went all the way up to the Supreme Court, petitioner and respondent. So people see all of these and they begin to sort of refer to everyone as a plaintiff and defendant, regardless whether it's on appeal all the way up to the Supreme Court. And so you're going to see a change in the way that those folks are referred to. And one of the reasons is that it's very difficult, for example, on appeal, to call the person that's bringing the case the defendant, right? Because the plaintiff won, and calling the person now defending themselves against that the defendant gets confusing. So we give them different names: appellant, appellee, and so on. All right, getting back to the matter at hand. So it should be pretty straightforward what we mean by plaintiff and defendant. Now, there's always got to be a cause of action. Why are you acting? Why are you taking this step? There's got to be a cause for that. If you remember going all the way back to the beginning of the semester, you're going to have to demonstrate that the court should hear the case, right? And what the court is interested in are things like standing, right? Whether you belong there, whether or not the case is right or moot or what have you. So first, what's the cause of action? Right? In a civil lawsuit, right? That's what it's called, a cause of action. And each cause of action has to consist of elements that the plaintiff must prove in order to prevail. We're saying the defendant did this. That particular thing we're saying they did has elements to it, right? That the statute lays out or the ordinance lays out. And so what has to happen here is the plaintiff has the responsibility, right? Because under our system of jurisprudence, what we assume is that someone's innocent until proven guilty. Now, here's a quick thing, a thing to keep in mind, that the court doesn't decide innocence, In other words, the defendant might be found not guilty. No one's saying the defendant is innocent. The defendant could have done it, but the plaintiff didn't didn't to have their cause of action. They did not really find the facts or bring the facts that would allow them to prevail. You got to prove it, and you and I, looking at it, may know that the defendant was guilty, that they did it. It's obvious that they must have done it, but the plaintiff doesn't bring the evidence. So it's what you can prove, not what you think. I like to use the O.J. Simpson trial. I feel comfortable saying that most people in the country believed that he did kill his wife, Ron Goldman, that he did it. But the prosecution, it was a criminal case, the prosecution wasn't able to make that argument supported by facts. The facts became very, very hazy. And so he was found not guilty. No one said he was innocent. And of course, we have a double jeopardy rule in this country, so you can't charge someone twice for the same crime. Otherwise, that person would be constantly brought up before the court. I think presently in Italy, for example, that rule doesn't apply. So you can keep bringing someone up. If we found some new evidence, you're back in trial again. You have responsibility under our system to get everything you need before you bring the case, because there's no redos. Unless there's some sort of a mistrial, but there's no doing it again, right? If it's there is no mistrial, if there's no problem, problem with that, you don't get to say, well, we found more evidence, let's do this again. You have to get it as a general rule. There are always some exceptions to these things beforehand. Okay, so when we talk about a cause of action like negligence, right? The statute says, right, that you have a duty to someone. There's a breach of that duty, and that breach of the duty is the proximate cause of the damages. So the elements that are at work here that the facts have to apply to in order for there to be negligence is that there's a duty. Then there's a breach of that duty, and then that duty is the proximate cause of the damages. So just stop and think about that for a second. Can you have a duty and breach the duty, but really it didn't cause the damages? Yes. Does that satisfy the standard of negligence? No. In other words, you can't be held responsible. You have a duty, you breached that duty, but what occurred afterwards, the damages that were caused, had nothing to do with your breach of duty. Now, of course, in court, what you want to do is you want to demonstrate that, yes, there was a proximate cause, that this was the proximate cause of the damages, right? So, okay, think of it this way. You're walking across a bridge, and as you get to the end of the bridge, you see there's someone drowning, but you don't see them, and you keep walking. Now, do you have a duty to help that person? If you didn't recognize it, the answer is no. No duty was created. Now you're coming across the bridge, they're in the water, you hear a scream, you look at them, and you see them yelling for help. And you go, oh, wow, this person's going to drown. And you keep walking. The fact that you saw them, does that create a duty? And if it does create a duty, right, then you breached the duty. You didn't do it. You didn't meet your obligation. And then the person drowns, or that person doesn't drown but suffers enough brain damage because of oxygen deprivation or whatever, and they can't, they can't really function anymore. That was a proximate cause of what happened to the person, or wasn't it? See, that's the argument. Now, just watch how the facts could change here. The person coming across the bridge sees the person drowning, so some sort of duty's been created, and then the person runs down to the shoreline and sees the person drowning, and the person saying, help, and the person just looks at them, and then the same outcome, right? Brain damage and so on. But it turns out the person that didn't help, that had the duty and then breached it, can't swim. So should they jeopardize their own life to save the life of this other person? These things get really complicated. It's not always as simple as it seems, but nevertheless, in negligence, it can get a bit, as with all things, a bit dicey. So I'll give you another example. There is, and I may have talked about this and briefly touching on as an example before, but I think it's one worth driving home so you can kind of keep all this in mind. So there's two families, they summer at the same houses next to each other every summer. There's two boys, that one from each family, that became friends. One is a few years younger than the other, but the older boy has a jet ski. And all summer long, the younger boy goes out on the jet ski with the older boy, sort of controlling the thing. This goes on for the first summer, second summer, third summer, fourth summer. Finally, in the fifth summer of doing this, the younger boy is now old enough to be able to get a jet ski. So he tells his parents, I want to get a jet ski. And his parents say, sure. So mom takes him down to the local jet ski store and says, I'd like to buy a jet ski. And so the, obviously the proprietor, the person who owns it, says, okay, well, he's old enough. Sure, what model would you like or whatever? And they look at it and they decide on a particular model, right? It's the same model, by the way, just slightly updated, that he's been on, riding on with the older boy for several summers. So they get it, and the proprietor says, we offer a class to teach, new kids, kids that are new to this, first-time riders, how to take care of it, what kind of precautionary measures they should take, what's proper use of it, and so on. And the mom says no, because he's been doing this for the last 4 or 5 years. He's really well acquainted with all of that. And said, okay, so that's fine. So goes ahead and sells the jet ski. Kid goes out on the jet ski. There's some malfunction. He loses control, and it crashes into a dock. Kid gets hurt. The mother gets a lawyer, and they find out that particular jet ski, the manufacturers had some problems with. And the manufacturer let the store owner, the proprietor, know that 1 in 1,000 of these may have this malfunction, and here's how you got to deal with it. So the mother finds out, the mother's lawyer finds out that, hey, the manufacturer knew that this thing was defective. They sold it to the store anyway, told the store, there may be a defect. They sell it to this woman and say, hey, you want to, take this class? She says no. All right, so who's negligent here? I think the first impulse is to say, well, it's got to be the guy in the store. He knew about it, right? That there's a possibility that this thing could malfunction. But it's the mom, right? She had a duty, right? He offered her the class to deal with things that might go wrong and how to deal with those things, right? How to deal with them. She said no. Now, I'm simplifying this whole thing, but she said no. Did she not have the duty to protect her son and say yes to the class? She waived that. The manufacturer said, look, there's a defect in about 1,000 of these things, but here's how you deal with it. And the store owner knew that, and part of the class was dealing with that in case it would happen. The mother waived all that. So why should the store be responsible or the manufacturer? They had a duty, the manufacturer, to either recall those or say, look, there's a simple fix here. We're going to lose a lot of money if we have to recall them, but you can fix this easily, so just make people aware of it. And the store owner said, yeah, okay, that seems simple enough. We'll put it into our class. And he tells her, look, you should take this class. You really should take the class. She decides not to. You make the argument that really she had the duty, she breached it, and her breaching of that was the proximate cause of the damages to her son. So I don't think many people would look at it like that. Of course, I'm not, our job isn't to argue out the case. But the point is the elements and how those elements get defined. Now, other court cases would define what a duty might be, other case law. It could be in the statute specifically what it is. typically statutes tend to be more vague than we would like because they can't be written in such an exacting manner that they would cover all possibilities, right? So, for example, you may say negligence, there's a duty, but they're not going to start defining under every single scenario what constitutes a duty. They're going to leave that up to the courts to decide. There's got to be a duty. The court will look at the debates that took place during the legislation and so on, look at the definition of those words, and they'll look at other cases, how other judges in that jurisdiction especially might have defined a duty. So they're saying, okay, well, look, this is how we define a duty. And in this case, there was a duty owed because these facts demonstrate that there would have been a duty. Okay? And so the importance here is that the vagueness of that language is necessary. It's not the legislators not doing their job. And typically, if they try and cover every basic, they end up with a 1,000-page, think of the Affordable Care Act, for example. That was a very long piece of legislation. You start hitting 1,000 pages and more. I mean, that gets very complicated. There's so many particulars in there that have yet to be interpreted. What that means, is that applicable? Can you do that? The Constitution itself, look how short that was. That was sort of a recognition of the fact that there were two things to consider. One was that a lot of the stuff was setting up a government, so that's pretty straightforward, right? You got to be a certain age, you've got to be a citizen for so long, when you'll all meet, what kinds of things you'll do. It's an organizational chart. But when we move away from those articles, which are just dealing with the setup, and we move into the amendments, now it gets dicey. You can't even really fully get past the First Amendment on freedom of speech. Cases, there's been a plethora of cases, and there will continue to be cases on what we mean by freedom of expression, freedom of speech. That's not going to end. The first Congress that put the Bill of Rights in place could not have thought of every possible scenario and then given a resolution for it in that amendment. It's like, look, you have this right. Now, the courts have to determine what was meant by that and whether or not the facts in the present case actually satisfy whether or not a person's right to express themselves was violated in some way. All right, so as we've already talked about this with this cause of action and gave the negligence as an example, the plaintiff obviously brings a civil suit in a civil matter against the defendant, and they do that through a complaint, which we've already gone over, right? And what is the complaint doing? It's identifying the causes of action and alleges that those specific actions by the defendant violated the law. Okay. Now, causes of action are often divided into separate counts, right? So there's a couple of rationales for this, right? One is that you want to keep certain issues separate, right? Not all cases, it's just a single issue. There are any number of issues. So the cause of action is divided into addressing those separate counts. The other rationale is that sometimes, especially in criminal cases, you get to get one bite at the apple. Remember, you can't double jeopardy. So sometimes they'll list degrees, right? First degree, and they'll go on from there. And the rationale there is you want to basically cover yourself. If you fail to make the case, for say first degree murder, you don't want to let that person necessarily walk. There will be other counts, right, that are included that are going to have to be dealt with here. So it's important to keep in mind that there's a function, of all that. So you get the cause of action, you've got this issues that relate to it, and they're divided into separate counts. Now, the burden of proof, the people that are responsible for coming up with the facts and making the argument that those facts demonstrate that element is going to have to be the plaintiff, right? For the plaintiff to prevail in a civil case, you got to prove those elements by, in civil matters, a preponderance of the evidence. Now, a lawyer, stock and trade are words, right? The laws, policies, right? Stock and water trades. All a preponderance of the evidence means is a majority of the evidence necessary. It doesn't mean you have to have more evidence than the defendant. It just simply, it means you have to have enough evidence to demonstrate the elements have been met to win the case. So if you have the majority of that evidence, then you're fine. Then you're likely to succeed. I'm not talking about the quality of the evidence, but the majority of it. So preponderance means you've got enough. You've demonstrated enough as the plaintiff that it's reasonable to hold the other party as liable. Now, I'm not sure if we're going to go into the next part or not. Okay, so what's the purpose then of the court? It's one of a few things, right, in civil suits. It's either to compensate someone for what they've suffered, or to return them to their original position, so they've lost nothing, right? So they've lost nothing. So the idea is to get them to the pre-injured state. So typically that's what a court's looking to do. If you can do either of those things, right? Think about standing again. If you can do either of those things, if it's justiciable the case, then if it's a civil matter, it's, well, we want to be able to fix the problem for you, right? And that means either compensate you for what you've lost, or somehow, deal with things in a way to get you back to the pre-injured state. Okay? So it's either fairly compensating for the loss or trying to get, someone back to the position they were in before. Now, damages, right, of course, as there were damages, you were hurt in some way, which obviously has to be the case. I like to use, and I've used before in the course, the idea of a broken heart. Courts can't adjudicate those. There's no way to compensate you. There's no way to assess the damages. And it's a natural course of living that, someone's going to probably break your heart at some point. It's an emotional thing. We can't do anything about it. Is it bad? Yes. People hurt? Yes. Could someone do that in a cruel manner? Yes. But it doesn't mean that it can be adjudicated by the court. They can't fix that problem. They can't unbreak your heart. All right. So the damages typically fall into one of two positions, or one of two types, sorry. Compensatory, they're going to compensate you for what you actually lost. This cost me, $1,000. The court's going to say, okay, we're going to compensate you for that. And the compensation can also include your legal fees and all that, so that you're, sure, you got your $1,000 back, but it costs you $3,000 to do that. So it also keeps the other side in check. You're not just going to, have to give them $1,000, but, they're going to be compensated for things as well, right? So otherwise, think about what might happen there. You've got a situation where someone says, look, we're going to do this, and we're going to take $1,000. The worst case is this person goes to court, and we say, okay, we'll give them $1,000 back, and that's the end of it. Or we have to go to trial, and this person's not going to go to trial against us because they don't have the resources, so we'll go to trial, and we'll basically legally bury the person, so they're not really going to go forward with it. So what keeps that in check somewhat is the court could say, you know what, you're now also going to have to not only compensate them for the $1,000, but for all their legal fees. Because this, you should have known this could have been settled, or whatever. We think that that's appropriate. Now you're going to have to pay for the legal fees. I don't want to go any further into that. Punitive damage is interesting because a court can go beyond, compensating someone. What they can determine is that this person or this party, the defendant, shouldn't have done this in the first place, and they're likely to do it again. If they believe they're likely to do it again, and that they were well aware of what they were doing, and the likelihood is pretty high that they're going to do it again, the court could give them award punitive damages, in a sense punishing these folks to try and prevent them from doing it again. Hey, not only do you have to pay them for what they lost, you had to compensate them for their legal fees, and now we're going to punish you for doing this because you're going to do it again. So we're going to raise the cost of you playing this game, and we're going to apply some punitive damages. Now, we don't know what those damages are, and sometimes they're restricted by law, which is a dangerous thing. Courts have tried to come up, what would be appropriate, punitive damages? Should we be able to drive the other party, the defendant in the case, out of business so they can't, and that's too costly. not for just the defendant, but the people that work for him lose their jobs. It gets messy. So there should be some reasonableness to it. Enough in punitive damages so they won't do it again, but not so much that you do great damage greater to them than really you would be necessary to prevent them from doing this again. All right. So you can get financial loss, you can get legal fees and all of that. And basically, again, in civil cases, it's just compensatory and punitive. Civil matters are about money, right? Basically, that's what it's about. It's about money. Torts are about money. Civil wrongs. And most civil wrongs, you're looking for some sort of financial compensation for them. As opposed when you get to criminal cases, obviously are brought by the government against individuals or businesses accused of violating some local, state, or federal law. Now, keep in mind, individuals can bring criminal suits against someone else. But if they feel they've been a victim of a crime, they can go to the authorities, local, state, or federal, and tell them their story and, say this person committed a criminal act against me. Now, they're not going to be compensated because it's a criminal matter. It's a criminal matter. If the district attorney or if the person, that's responsible for reviewing the facts thinks there's a case there, they can bring the case against the party that you're claiming committed this act against you. Okay? So things like battery, it's crime. And there are others, right? Burglary and the like. But, you report to the police will investigate, they'll see what facts are there, they'll bring the facts if they think they're worthwhile to the district attorney. District attorney will look at those facts and look at the likelihood of winning or not winning that case, or looking at the amount of resources and energy it would take to pursue that. Is it worth doing that, given the particular crime that was committed? For example, in domestic cases where there's domestic violence, it gets dicey because if one or the other spouse, we'll say they're married, keeps it simple, beats the other, okay, and hospitalizes them. Now there's been a lot of damage done. The person, it's going to take 3 months and physical therapy for that person to sort of get back on their feet. Now, that's pretty severe. But what happens if they get down the road and their primary witness, which is the spouse that was beaten, has a change of heart and says, I'm not going to testify. Okay? I wanted you to bring the charges and now I'm not going to testify. Well, you've just invested all this time and energy and you've got your primary witness now and the victim of the crime not willing to testify. Or if they do testifying in such a manner that your case grows weaker by the word, right, by the moment. So you want to fight the battles you can win. Now, some people would say that's horrible because this person's been beaten, but still, it's what you can prove. That's the system. It's what you can prove. And that means that some guilty people that do some horrific things can get away with it, right? Because they're found not guilty. Again, they're not found innocent. They're just found not guilty. Simply stated again means the facts you've brought before the court and what you've done are not enough for us to be able to say that this crime or what have you was committed. All right, so the burden of proof then in criminal matters is going to be, obviously whether the person is guilty or not. The burden of proof is going to have to be on the state, right? They're the ones bringing, the case. So they're going to have to prove that, that person did what they say they did. And, if the prosecution, which is going to be obviously the state, fails to, make a case based on the facts that the court sees satisfies the elements, then the person is found not guilty. Again, not innocent. Not innocent, but not guilty. The standard there, because you're talking about taking away someone's freedom, right? Possibly taking away someone's freedom or even their life, is not a preponderance of the evidence, meaning the majority of the evidence, however we want to define that. Court makes that decision. Jury makes that decision. But beyond a reasonable doubt. If you're going to take someone's life or execute them or whatever, or just lock them up for a period of time and give them a criminal record so the rest of their lives that follows them forward, reasonable we don't really define. That's really for the jury to define and for the judge. So the Supreme Court referred to reasonable doubt is doubt based on reason that arises from evidence or lack of evidence. So was there reasonable doubt? It's not, it's important that you can convince a jury that, that it is beyond a reasonable doubt, right? And so it's, again, it's something that gets defined. Did they prove their case or did they not? Oftentimes, again, it's practical. The average person listening to the facts will say this person did it. And then when the person gets off, they feel there's been a miscarriage of justice. But it's better, as the saying goes, it's better to let one guilty person, or 10 guilty people go free than it is to take an innocent person and incarcerate them or execute them. Now, I will tell you just as an aside, there have been studies that go back and look at DNA evidence before we had the capacity, the knowledge, the scientific ability to look at DNA. And what they found in about 50% of those cases where there was still evidence, because that evidence usually gets stored, that when they applied the DNA testing to it, that had DNA tests been available, about 50% of those people found guilty and executed would have been found innocent. It's one of the arguments made against capital punishment. Well, there's two that you hear all the time. One is it's irrevocable. If you make a mistake, this person's gone. You can't fix it. That's one of the arguments. The other is that it doesn't seem to really be a deterrent. States that have a death penalty don't see less homicides and the like. In fact, they see usually more, and which leads to the question: if you kill someone, you could lose your life in that state. Why would you do it there? Well, we assume that people that kill people are not normal, right? Normal people that have reasonable control over their faculties, get mad, and maybe they fantasize about it because they just are so angry, but they wouldn't act on it. Acting on it demonstrates there's a lack of normal sort of capacity. If there's a lack of normal capacity, can you hold someone responsible for acting in that way? They don't understand it's wrong. If you don't understand something is wrong, should you be found guilty of doing it? Or should you be found guilty of doing it and being punished or not being punished? I mean, what do you do? The strongest argument for incarceration is that at least they're out, they've been removed from the general population, and the likelihood of them doing it again goes down because they're incarcerated. But people that are for the death penalty will make the argument that somehow justice has been meted out, that basically this person deserved to die, they took another life, an eye for an eye, a tooth for a tooth, and being executed certainly means you can't commit a similar crime or even a lesser crime, because obviously you're not here anymore. And there are, of course, issues about how we go about executing someone. It used to be rather gruesome, and then we thought we found a humane way of doing it, which was a lethal injection. There were two injections. One was to relax you and make you, unaware of the pain, and then the second was inject you with, give you the lethal injection, which would end your life. And what we found out was that that first drug that was supposed to not make you feel anything and relax you so you wouldn't be freaking out, actually it just immobilized you. So you were feeling everything and you were freaking out. You just couldn't move. You just couldn't speak. And once we discovered that, we went ahead and we said, the court said, stop. You're going to have to find some other way of doing this, or some drug that actually does what you're saying it's going to do. Some people argue that it doesn't matter about that. It's just cruel. And there again, words, cruel and unusual. If you're taking measure to protect the person, in terms of what they're going to feel and all of that, then it's not really cruel. And it's not unusual if you've been doing it for a long time. It's not unusual to execute someone you've been executing people all along, right? Now, as a gruesome aside, which has nothing to do with this, but just to put this in perspective, we know that the least painful way of executing someone is to behead them. We're having this discussion. To behead them. But that is offensive to the public. We don't want to see it. We don't want to see that. We don't want to know about that. So this, lethal injection thing is kind of easier, I think, on the public to sort of accept. Okay, so again, it's the same though. This beyond a reasonable doubt is really about coming up with enough facts to demonstrate elements of the statute have been met. Say murder. Well, was it premeditated or not? Was it in self-defense? Just saying someone murdered someone is not enough. If it's in self-defense, well then, can you really blame the person? In other words, there are what we call aggravating and mitigating circumstances, right? Some things, two people get murdered. One, right, is a 6-year-old child. The other is a 60-year-old person, okay? There's something about, both are gone, but there's something about doing that to a 6-year-old that we find especially disturbing, right? And that's aggravating. That's what we mean by aggravating. Aggravating or mitigating circumstances raise or lower, really, the crime that's going to be charged. So with a child, we all feel that we never want this person, to be out on the street again. It's also the manner in which that took place. Was it quick? Was it especially torturous? All of those things are aggravating. Now, mitigating factors, we think of things like self-defense, right? So when we have aggravating, the punishment is usually more severe. When we have mitigating, like self-defense or the like, that tends to decrease the severity of the crime. If something is meditated, that intends to increase, right? It's an aggravating factor because the person had time to think about it. They plotted it, they planned it. At any point along that way, from the moment they thought of it and started to plan it out to the moment they executed the crime, at any point along that way, they could have come to their senses. And they could say, I can't do this. If it's spontaneous in the moment. So, there's the, let's see if I can remember it. I always forget the writer's name. And I don't want to blame the wrong, writer. Anyway, there was a writer and who had several movies made from his books. And he found out that there was one, I wish I had more of the exact, but you could probably figure this out if you Google it. He argued that someone should be let out of prison because they were a great writer. They wrote well, and somehow this writer felt that made them somehow different, right? And they managed to get the person out of prison. And so the person goes out with a few people to have dinner at one point. He says something to the waiter that serves him, and the waiter's had a somewhat bad day. And he says something back to the guy. I don't recall what that was. Something like, get it yourself. And the guy that was released from prison says to him, you want to step outside? And the guy's a little hot, the waiter, and he says, yeah. And they go outside, and the guy that got released from prison takes out a knife and puts it right in his chest. And apparently eyewitness said that the waiter, says, you didn't have to do that, as he's falling to the ground. See, the waiter thought, okay, we're going to have a pushing match here, and it'll be over with. But this guy was so offended by what this guy said to him, get it yourself, that he felt that person needed to die. Of course, the person, the writer who helped get him out of jail, this dogged this person for quite some time. You see this, and when it happens again, it's we think of justice as somehow being infallible, but it's not. It's not uncommon to see these sorts of things. Roman Polanski was found guilty, basically, of raping a girl, underage girl, and then was going to strike a plea bargain and fled the country. Many years later, he was, and no one would extradite him, send him back to America to be, served or be penalized. But eventually, many years later, he was taken into custody and brought back. And he was a great director. I think he was director. Yeah, director. And all these other people in Hollywood signed a petition saying, this is crazy. This person, is a great artist and should not be charged with this. And the now woman, not the girl, but the now woman, doesn't want the case to be brought up again. Obviously, she's got a life and she doesn't want to go through it again. And people were on one side or the other. This person should not be punished. And by the way, he never argued he didn't do it. He couldn't understand why people were upset about it. That's the story as it was at least put out to the public. So there again, we find some of these things really offensive, but the reality is that we can't do anything. Justice is not perfect, and neither are people, obviously. All right. So aggravating and mitigating circumstances. All right. I want to talk about case law so you understand what that is. When you get a judge that interprets the law, they've got a statute or ordinance, whatever, then that decision that they make is referred to as case law. They looked at the case, they interpreted things, and there it is. Okay? So you have a statute, but the statute's going to be interpreted. And how the court interprets it is what we call case law. So that's how it's been interpreted and applied by the courts. That's instructional. So why? Stare decisis. We're looking for the courts to make, based on similar facts, to come to similar conclusions, to draw similar conclusions. That being the case, it's important that there be some consistency across the board and over a period of time. Why? We have to define things, and we'd like our definition of things, right, to be consistent. If you start changing the meaning of things, it's harder to know what the law actually means, what the statute or ordinance really means. And therefore, your behavior, you don't know when you're crossing a line. I don't know what this law means. It's been interpreted in so many different ways. So one of the primary goals of any court, any judge in writing, an appellate court writing a decision, is to make sure it's consistent. Or in a trial, making sure it's consistent with the application of that law in the past based on the facts that have been presented. So yes, these facts, judge determines, satisfies these particular elements of the law, and this is how those elements have been interpreted, which means these satisfy that because you can draw a link and decides the case as other cases like this have been decided. And that keeps going, right? And then it's precedent, right? It means it's something we can look at every time it happens. It's precedent. Now, it gets to a point where maybe the facts no longer support that particular statute, or that statute on the face of it can't fly. For example, in the case Plessy versus Ferguson before the court, the general rule of thumb, separate but equal, was fine. You had water fountains, as an example, that whites could use, and water fountains that were at least determined as coloreds could use. And they said, well, you both have water fountains. So what's the big deal? Separate, yes, but they're equal. You both have water fountains. Fast forward to Brown versus the Board of Education, a few decades later, and the court looks at it and says, wait a minute, we've been making decisions based on the separate but equal standard, but separate but equal doesn't make any sense. If something's separate, it can't be equal. And so that standard is thrown out. And that case sets a new precedent. Now we're looking at a different interpretation, right? And so that then determines all the cases moving forward, because that new precedent now moves the other ways in which these cases were decided off the table. And now they're not of any significance in terms of how the courts should move going forward. We still have the same problem interpreting things. That doesn't change, but the way we look at that particular standard has changed, right? Okay, so what you have to be able to do is to look at that case law, right? That's binding in a particular court, because it helps us figure out what those rules mean, what those laws mean, so people and lawyers can understand what we should be doing. If you start changing what things mean, then what do people do? I mean, how do we behave? Okay, a really severe, it's not really an example of it, but to kind of make it clear in your head, an ex post facto law. So today, it's okay to have, an ice cream cone on the street, and while you're walking. Tomorrow, the legislative body decides no ice cream cones on the street. They sometimes fall off, they're slippery, whatever the argument is. I know this is insane. Okay, so no ice cream cones on the street when you're walking. Someone says, wait a minute, I saw Allison and she had a cone yesterday on the street. And they say, well, let's prosecute her. She broke the law. You can't retroactively apply a law. An ex post facto law means we're going to punish you today for something you did yesterday or, previously, when this law didn't exist. How can you violate a law that doesn't exist? And then when it does exist, they retroactively charge you with something. I go through that so you can understand the difficulty if you are deciding cases in a way that are inconsistent. It's not as bad as the ex post facto law, but we still are confused about the law. I don't want to break the law, but I need to know what it is. And I need to know how the courts have viewed it, so I'm certain of what it is, so I don't run afoul of it. If it's been determined in so many different ways, we really don't understand what it means, the likelihood of violating it goes way up. Likelihood of violating it goes way up. Then, you don't have really a very, you don't have a very strong legal system because, in essence, there are no laws. They're whatever the court decides on a given day. And the one thing about law is it needs to be consistent. Consistency in law is everything. You breach consistency, you have no law. So interpreting laws in a similar fashion, using the same sort of structure, the courts using the same sort of structure, helps us know what the law is. And so, we may not like it, but it's perfectly legal, then it's legal. And if you don't like it, you have to get your legislative bodies to write new law. That goes all the way from the most basic ordinances all the way up to the Constitution of the United States. One of the ongoing sort of conflicts is we know the president has a right to appoint judges to the Supreme Court with and by the advice of the Senate. So the president nominates someone for the Supreme Court, right? The Senate interviews that person if you're right. They come before the Senate, and then the Senate votes whether they want to recommend it to the entire Senate and say yes. We give our consent, so now this person could be appointed to the court. The argument is a president that's serving out either their last term, so they can't get reelected, certainly in that manner. That's what I think would be the strongest sort of argument. Or a president that's the end of one of their terms, like the first term, right? Second term, you have a stronger argument, but it's still constitutionally makes no difference. Because the argument is this president who's ending their first term or who's certainly ending their last term, there's only 2 terms allowed, shouldn't be nominating someone, and that person shouldn't be appointed to the court because it's the end of their term. And really, they should allow the next president, if it's them that gets reelected for their second term, then fine. But if it's someone else that wins the election, that person because that's the most recent person elected, should make the decision about filling a vacancy in the Supreme Court. Well, it's not unconstitutional. In fact, it's perfectly constitutional for a president right up to the last day in office. And this wouldn't make sense because obviously there's not enough time for the Senate to consider it, and there's also elections that took place in the Senate, so it's a little murkier. But let's say it's 2 months or 3 months before the new president might come in or what have you. There's nothing wrong with the president nominating someone and then the Senate hearing it and consenting, and then that person getting appointed to the court. You may not like it. You may say it's not fair. You may say all those things. But you can't argue with the fact the Constitution says that's how it's done. So really it's a political question, right, whether the president should do that or not. And people get all upset about it. But both sides and Democrats and Republicans have been both in that situation. They both argued both sides, depending upon whether their ox was being gored or not. So if you're a Republican and you have a Republican Senate, you're going to want to nominate and you're going to want to consent and appoint someone, right? Even if it's in the last few months of that president's term. The Democrats will jump up and down and say, this is not appropriate. It should be, it shouldn't be done this way and so on. Flip it, have a Democratic president and a Democratic, controlled Senate, and the last few months of a Democratic president doing it, right? They'll say it's perfectly okay, and Republicans will be jumping up and down saying this shouldn't happen. So, well, they're politicians, right? So, but from a strictly constitutional point of view, forget the politics of it, the president has a right to do that. Okay, and that's been very consistent. Especially with the Constitution, we want to be consistent because that's the founding document and the fundamental document that we all sort of expect to keep the nation on the moving along on the straight and narrow, so to speak. Okay, I'm going to end this lecture here. There's one more lecture to go, and we'll pick that up next time. So we're going to go over next time sort of the order of a trial, how that happens, give you the nuts and bolts of it. Again, the idea here is, right, not to turn you into lawyers or this is not law school, but if you're going to do a mock trial, to have an understanding about how all this works, but also, even if you're not, to understand what the law is, understand how we look at it, understand the differences between things like case law and so on and so forth, what precedent is, how a trial works. It's important for every citizen to understand how their legal system works. Not just, you get arrested, something happens, but the nuts and bolts of it. Because the more you know about it, the better off we all are. The one responsibility, I would argue, that every citizen has is to be a sophisticated consumer of political information. That's the point here. So you understand when there's a problem and the policy gets written and it gets challenged in court, you understand how all those things happen. What the problem is like, why the policy was made and how it deals with that problem, and then how the court interprets it. The more sophisticated citizens are, the better off we all are. So understanding whether you're going to do mock trial or not, understanding the process, the legal process, and what it all means is absolutely essential to being putting a citizen in a position of greater strength and having the ability to more effectively advocate. And that's essential in a republic. We need to do that. All right, so we'll pick it up next time. That ends this lecture.